everybody, welcome. Thank you for joining me today for our favorite topic, contracts. My name is Mike Infanti and I am the owner and operator of Preferred Settlement Services here in Sarasota, Florida. I'm a practicing real estate attorney, have been practicing for over 25 years here in Sarasota. And thank you for taking your time out today to join me for this seminar. Couple introductory sort of things. We have a lot of information to get through today, so if you haven't already, you might want to stop and download a copy of our form contract here that's on the screen. It has a place to take notes and that sort of thing. And then in addition to that, you should have a link for also our line-by-line commentary, which kind of goes through each provision of the contract and gives more specific commentary. That sort of thing should look something like what you see on your screen. So if you haven't done that already, you might want to just stop and download a copy of that. Or if you can't find it, certainly reach out to our office. You can email us at any time at info@preferredsettlement.com, or you can always email me directly at minfanti, that's INF as in Frank, ANTI, at preferredsettlement.com. So like I said, we have a lot to go through today. The good news is, especially for, well, really anybody, but some newer agents, if you don't understand something or you have more specific questions, whether it's on the contract or really anything else, whether it's about addendums or anything, you can always reach out to us. You can call us, send me an email, send us an email, and we'll get back to you and try to answer any questions that you have. So don't feel too overwhelmed with that. One last note is, if this seems a little bit long to you, you can double speed the speed of this video, so you can increase it to 1.2x or 1.5x. Makes it go by a little bit quicker if that's something that you're interested in. So with that, guys, we'll jump right into it because I don't want to take up too much of your time here. We're going to focus today on the as-is contract, right? So there's two different types of contracts. There's the as-is contract and what's called the standard contract. Both contracts are approved by the Florida Bar and the Florida Association of Realtors. The fact of the matter is the provisions in both contracts are pretty much identical. Almost all the provisions. The only difference, of course, are the inspection periods, being that with the as-is contract, the buyer has the right within a certain period of time to go through, make their inspections, cancel for any reason. Under the standard contract, buyer doesn't necessarily have the right to cancel. They have the right, of course, to go and do their inspections. If there's repairs that are needed, the seller is obligated to make those repairs up to a certain point, and then if the repairs go above that amount, then the seller has the option to either make those repairs or cancel the contract. So that's really the main difference between the two. Both are approved by the Florida Bar and the Florida Association of Realtors, like I said, and both are great forms in that they're time tested, and they also, really kind of balance the interests of the buyer and seller, and I think are fair to both parties. But it does seem to be these days that most realtors are using the as-is form, so that's what we'll focus on today. If you have questions, about the differences in the forms or whatever, like I said, you can always reach out to me. We can talk about it, and happy to answer any questions that you have. I would recommend for any realtor really to understand, though, the differences between the two types of contract, because your clients will ask you, hey, should we do an as-is, should we not? And it's always best if you're familiar with both versions of the contract so that you can explain that to them. One question I do get a lot before we kind of jump into the contract itself is, hey Mike, if I use an as-is contract, does that mean that my clients don't have they're waiving their rights to warranties and that sort of thing? The answer to that is no. Under Florida law, a seller is obligated to disclose anything that could have a material impact on the value of the property, regardless if it's an as-is form contract or a standard contract. The seller still has the same obligations to disclose that and still has the same implied warranties if they fail to disclose that. So the reps and warranties are basically the same in the as is or in the standard contract. Again, the as is just means you're taking it, not requiring the seller to make any repairs to the property. So with that, guys, let's jump into it. I'm going to, like I said, this version that you're seeing in front of you is the version that you have a link to so that you can take notes. I'm going to use just the larger version of the contract so that we can kind of go through it in a little bit more detail. So, you know, I'm going to kind of take this a little bit slow, so bear with me. You know, the first provisions that we have are the seller and the buyer's names. Seems pretty straightforward, right? Buyer's name, seller's names. Well, some of the questions that I get from time to time are, well, Mike, what happens if it is a seller LLC or, you know, or a trust, or the buyer is taking the property in their individual names, but then want to convey it to their trust later, that sort of thing. So there are some things to sort of be aware of. By the way, as many of you know or will experience, sellers will often say, you know, yeah, put in my individual names, Mary and Joe Smith, but then they forgot, oh, they put it into their trust or they put it into their LLC, that sort of thing. Well, what happens if you sign a contract that is in the wrong name of the seller, right? Guess what? It's not enforceable in most cases. So, you know, if you're representing a seller, I think the best thing to do is go to the property appraiser's office, take a look at how it's titled, just to confirm, make sure the names are correct, that sort of thing. If you have a buyer that says, oh, we're not sure if we want to take it into a trust or whatever, what do we do? My suggestion is put it into their name as currently, you know, their name, and then have the assignability checked in the contract, which we'll talk about in a moment. That gives them the ability to assign it to their trust or LLC or whatever prior to closing. So there's that. Property description, again, pretty straightforward. Nothing really to be too concerned about here, other than you don't really need to put in the, you know, it has a place for the legal description. Florida law says if there is a street address or property identification number that can adequately identify the property, then you don't really need a legal description. Of course, you can put one in, or a partial if you can find it on the property appraiser's website, that's fine too. All right, personal property, going down to this section D. Personal property, pretty self-explanatory, right? What personal property is going to be included or excluded from the sale seems to be pretty straightforward. However, there's a lot of howevers, aren't there? Anyways, you know, there are times where I've seen people get into problems in a couple different ways. One is where it's, quote, turnkey furnished, right? Well, what does that really mean? We've had some closings recently that got to closing, said turnkey furnished. It was a very expensive home, had very nice furnishings, that sort of thing. The seller went in before closing, took out, you know, all of the nice, you know, fixtures and that sort of thing, and, you know, replaced the dishes and whatever with Target brand, much less quality and value, right? So their point was, well, it just says turnkey furnished, doesn't say the existing furniture, doesn't say this, doesn't say that. So, you know, I know it seems silly, but people do silly things. Trust me, I've seen it. So, you know, there's that. There's also, you know, does turnkey furnished mean everything? What about rugs, right? Is that included? Whatever. You know, you get to closing and the rugs have been removed, and they said, well, it's turnkey furnished, right? Are rugs part of the furniture? I don't know. The thing is you may have a buyer that really loved those rugs and was expecting to get that, right? So my point is, guys, if there are specific items of personal property that your client is interested in, make sure that you clearly identify it here, or certainly in an addendum if you need to. If you're really doing it turnkey furnished, I would suggest to you, you know, go through, take the time, have a specific addendum that identifies all of the items that are important to your client. Or if you don't want to take the time to do that, at least go through and take a video of the furniture that's in their furnishings, and make sure that that this paragraph is comprehensively filled out. All right, purchase price. That's that is self-explanatory. Don't need to talk about that. Initial deposit, right? Initial deposit is going to be held in escrow, and the initial deposit is delivered to the escrow agent, who we'd love to be the escrow agent, by the way. But here's the important part, right? So check one, accompanies the offer or to be made within blank days after the effective date, right? So let's first talk about effective dates. Effective dates are important, guys. The effective date is the date that the buyer and the seller have signed the contract, but also delivered it to the other party, right? So here's an example. Buyer and seller are negotiating over the weekend. The contract, you start negotiating on Saturday. By Sunday, everybody's signed the contract. It's good to go. And so the buyer sent it to their agent, but said, hey, we're busy tonight. If you can't get it over to the seller until Monday, that's fine. The agent gets busy and doesn't end up transmitting the contract that was signed on Sunday, but doesn't transmit it to the seller until Monday. Well, guess what? The effective date, even though on the contract the dates are Sunday, right? Because that's when everybody signed it, that's the date that they put in, it actually wasn't sent to the seller until Monday. The effective date is Monday, even though in the contract it may have dates that show that it was signed on Sunday, right? So Monday is the effective date. So it's important to kind of make sure that you're calendaring that, because all the other critical dates in the contract run off of the effective date. So make sure that you're calculating that correctly, keeping track of that, and that sort of thing. And then this here, the deposit is to be made within 3 days after the effective date if left blank. So 3 days, right? So that's 3 days from the effective date. So in our example, the contract was signed on Monday, right, or delivered on Monday. So the effective date is Monday. So we have Tuesday, Wednesday, Thursday. The deposit is due Thursday, right? So it's 3 days from. Sometimes people say, well, do I include Monday? No, you don't. So it goes from the effective date. So again, Monday, Tuesday, Wednesday, Thursday, the deposit is due on Thursday. Again, what happens if it was signed on Thursday, right? So then you have Thursday, Friday, Saturday, Sunday, the deposit is due on Sunday, right? No, it's not. There's an automatic provision in the contract that says if a date falls on the weekend or national holiday, it automatically extends to the next business day. So again, it doesn't change the date that you would calculate it. So again, Thursday, Friday, Saturday, Sunday still would be due on Sunday. However, it's extended to the following business day, which of course is Monday. So make sure that that you're keeping track of that, and that you're staying on top of those deadlines. The other thing to be mindful of, guys, is, and of course many of you know this, but there's a theory in law, contract law specifically, that talks about the four corners of the contract, right? What does that mean? That means that all the terms of the contract are generally included within the four corners of the contract. In other words, everything that is in the contract that you really need to know is in the contract, but the contract itself is what counts. And the reason why I'm harping on this is because dates matter, critical dates matter. When we talk about a deposit being due, it's not kind of, sort of, maybe it's due on Monday or whatever. It's due on Monday. And so, oftentimes we have clients that are busy, maybe they're flying, maybe they're busy with work, whatever, and the deposit is due on Monday, and they say, I can't get to, I'll get to it tomorrow. Well, guess what? If the deposit is due on Monday and you get it to the escrow agent on Tuesday, you're in default. The buyer would be in default under that example. What does that mean? That would mean technically that the seller could make a claim on that deposit. So it was due Monday, they didn't make it until Tuesday, right? Guess what? Tuesday, 4:00 p.m., the seller calls the escrow agent and says, did you get the deposit? Or when did you get the deposit? We got it today. The seller can then say, well, he's in default, so A, I'm going to terminate the contract, and B, I'm going to make a claim to his deposit, and C, guess what? I get to put the property back on the market. Does the seller have the right to do that? Absolutely. Would the seller under that example, would the buyer under that example have any right to prevent the seller from getting their deposit? No, he wouldn't. Does this happen? It absolutely happens, and it's unfortunate, especially when sellers are looking for leverage. Maybe they got cold feet. Maybe later on during the transaction, they think they can sell it to somebody else for more, and they're looking for a way out. And they call the escrow agent and say, "Hey, I'm just confirming. When did you get that deposit?" And guess what? The escrow agent under law can't lie, right? So, what we would do typically is we'd reach out to everybody to let them know, hey, we got this inquiry, and try to resolve it before it escalates. But the fact of the matter is the escrow agent has to, of course, be truthful. And if the buyer's defaulted, the buyer's defaulted. So anyways, long way of saying, make sure your clients understand time is of the essence, right? If it says it's due by Monday, it's due by Monday. Make sure they have it in, and make sure they're aware of that. All right, the rest of this is pretty straightforward. So we got additional deposit if it's applicable. I guess I'll go back to that escrow agent. Again, guys, we'd love to be your escrow agent, preferred settlement. We work very hard for you and for your clients to make sure that your closings go as smooth as possible. All right, financing, enter a dollar amount or percentage, right? So or percentage there, so you can put in 90% of the purchase price, whatever, you can put that in. But you do want to put in an amount or a percentage, because that loan amount, whatever you put in, this 2C, is going to be the financing amount that the buyer will be tied to their financing contingency in the later part of the contract. So you want to fill that in. All right, section 3, time for acceptance, right? So this kind of throws people off sometimes. Time for acceptance. Why is it in there, and what does it mean? The reason for the time for acceptance is really, guys, you don't want to, if you're making an offer, if the buyer is, for instance, filling out this contract and submitting it to the seller, they don't want this contract just to be lingering out there forever, right? Because if they give it to the seller and the seller just sits on it and then comes back 2 weeks, 3 weeks, a month later and says, "Oh, I accept," that would be obviously problematic for the buyer unless they rescinded their offer. So what this does is it puts in sort of an automatic mechanism to say, hey, this offer is only good for a certain period of time. If you don't accept it, it automatically expires. Sometimes I see a couple days here. Sometimes I see it as short as by the end of the day. And sometimes I have sellers frantically calling me saying, hey, I got this offer from this buyer and it's going to expire today. What do we do? What do we do? And I tell them, don't worry about it. Basically, if they're interested, we'll have enough time to, well, first of all, I'd say, well, let's see if we can get it done by the end of the day. But if we can't, I don't want sellers to feel overwhelmed. That's just, kind of perfunctory, if you will, to kind of put in the contract. Yes, technically their offer will expire, but then if we make changes to it and we resubmit it back to the buyer, it's a counter offer, and then they have the option to accept it. So anyways, these dates can kind of not be too worrisome. Although I will say, and I don't want to get too down into the weeds on this, but you can have situations where a buyer submits an offer to the seller, let's say by 5 p.m., and the seller doesn't accept it by the end of the day. Let's say they get busy. Let's say they receive an offer on Monday that will expire by 5 p.m. on Monday, right? The seller gets very busy, and they sign the contract without making any changes to it, sends it back to the buyer Tuesday afternoon. And since the buyer already signed it, the buyer doesn't initial anything because there weren't any changes made or anything else. Well, guess what? That offer was terminated. The seller then signed it and sent it back. That would be considered a counter offer, of which then the buyer would need to sign. Anyways, I don't want to get too confusing here, but my point is that if you're beyond the timeline specified here, you want to make sure that all parties have signed off and agreed on the final terms. All right, guys, closing date, obviously put that in here. You know, I think I'll mention this just because I think it's kind of interesting. I recently had a closing where the seller was an attorney, and this said shall occur on or before, I'll just use a hypothetical here, October 31st. And so on October 15th, I get a call from the seller saying, okay, I'm ready to close. And I say, well, okay, but the buyer's not ready yet, and it says on or before October 31st, so I don't think we're going to be able to close early. And his response was, well, that's not what the contract says. It just says on or before, and I'm choosing before, so I want to close on October 15th. Show me in the contract where it says that everybody's got to mutually agree. It just says on or before, I'm choosing before, let's close. Well, you know, I won't say, you know, what I said to that attorney, but the point being that particular seller was looking for leverage, right, to seek certain concessions from the buyer. And so this was a roadblock that he kind of put up that we then had to kind of, you know, fumble through. Eventually, of course, we got the deal done, but it wasn't having to go through some issues. I think that ultimately, if it were really to go anywhere, I think the court probably wouldn't see it that way, but I just thought it was interesting. It's an interesting sort of argument. My point being, if you want to put in on or before, I think it's still probably fine. If you want to put in on or before, you know, October 31st upon mutual approval or upon mutual agreement or something like that, or put in the additional terms or whatever, you can certainly do that. I just, you know, on or before, I think it generally has the meaning that's intended, which is upon mutual consent. But technically speaking, I suppose it doesn't say that. I kind of just bring that up just as an interesting sort of side note. All right. Extension of closing date, the CFPB, we won't go too much into that. But then here, this goes on in section B to talk about in the event of a force majeure causing services essential for closing to be unavailable, including the unavailability of insurance, closing date shall be extended as provided in Standard G. So we'll talk about Standard G in a moment, but I just wanted to kind of point that out to you because especially for newer agents, maybe, you know, sometimes we do get these things called hurricanes here down in Florida. Not today, thankfully, but we do have hurricanes, right? So sometimes you have frantic buyers going, "Oh my God, my closing scheduled for October 31st, but I can't get insurance. What do we do? Do we have to do an amendment to the contract to extend until after the storm?" Blah blah blah. No, you don't. It's already in there that it's already going to be extended per standard. Same thing can also happen when a hurricane comes through and there's certain unavailability of utilities and that sort of thing. So again, we'll kind of go through that more. Occupancy and possession, section 6, subpart B, just talks about leases on the property. You know, if there is a lease on the property, this section 6B should be checked. Again, check with your sellers. Sometimes, you know, these sellers, they forget to tell you, maybe, oh, I forgot to tell you there's a lease, or hey, I forgot to tell you we Airbnb'd it because we're going to be gone for the Christmas vacation, and so we Airbnb'd our house and that sort of thing. So obviously those need to be disclosed to a buyer. Some questions I get here sometimes are, hey Mike, I have a buyer that's buying a property, it's subject to a lease. If we close, does that automatically terminate a lease? The answer to that is no. The lease would have priority over the terms of the contract. So the new buyer of that property steps into the shoes of the seller subject to the existing lease. So if the existing lease says that it's going to go through December 31st and closing is on October 31st, then they're going to assume that lease on the same terms and it will continue through the end of the year. So no, a closing does not automatically terminate a lease. All right, section 7, assignability, right? So This is buyer may assign and thereby be released from the contract. Buyer may assign but not be released from the contract, or buyer may not assign this contract at all. As most of you may know, oftentimes the second option is checked. Buyer may assign but not be released from liability under this contract. That is probably the most general sort of option. Again, if you're going back to what I said at the beginning, if you have a buyer that says, I want to sign this contract in our names, but we may put it into our trust or entity prior to closing. If this box is checked, may assign but not be released, then they automatically have the right to assign it to their trust prior to closing. Doesn't need seller's consent or anything else. We will prepare the assignment for you and for your clients at no cost, of course, and that sort of thing. So it's a fairly easy process. If it is you can't assign, right? If this box is checked, then the buyer could not assign it to their trust without getting the seller's consent. If this first option is checked, buyer may assign and thereby released. That's not a great option if you're representing the seller. Why? Because this would allow the buyer to essentially assign it to a shell company, right? So they open up an LLC that has no assets. They assign it to the LLC. The LLC doesn't have any assets. He says, I'm not closing, or the LLC now is not closing, and the seller wouldn't have any right. I guess they'd have the right to keep the deposit, but in any event, most sellers don't like having the buyer be released from liability. So again, the second option, most common. All right, financing, the fun part, right? All right, section 8B. Obviously, if it's a cash transaction, that's going to be 8A, but we'll focus on 8B here, right? So the contract is contingent upon a certain amount of days to get financing, usually 30 days. In my experience, these days, 30 days is generally enough if they've already started that process with their lender. If not, if they haven't even made the first phone call, you might want to go for a little bit longer. For conventional FHA or other mortgage loan, typically here you're going to want to put conventional and then check one for fixed, adjustable, or fixed or adjustable rate loan. Normally it's going to be fixed or adjustable rate loan at the interest rate not to exceed, if left blank, then the prevailing rate based upon buyer's credit worthiness, right? So that's probably what you want there. Probably best not to put in a specific interest rate. You just leave it blank and then it's at the prevailing rate, right? And for term of, if left blank, 30 years, that's fine too. I like to fill in, blanks if I can. So if it's 30, I still like to write in 30 just to make it clear. Of course, doesn't have to be if it's left blank. That's fine too, but I think it's a little bit more complete. Even though you're going to put in 30, I still put that in instead of leaving it blank. All right. So it has 30 days to get financing, and then to having received an appraisal, right? So this is they have a loan contingency period under our example, 30 days basically to get financing based on their credit worthiness for a term of 30 years and get the appraisal within that period of time, right? All right, so they have a certain period to get all that done. Buyer shall make application for finance within 5 days after the effective date and use good faith and diligent effort to obtain loan approval, right? So what does that mean? Well, guys, again, going back to that time of the essence, right? If this is left blank, the buyer has 5 days after the effective date to make application to get a loan, right? So if the buyer hasn't already made that application, then they have 5 days. It's not 6 days or whatever. And so, again, guys, if there's dates in the contract, make sure that your clients are complying with them. Again, if the seller later is looking for a way out, or to cause or look for a way for the buyer to be in, let's just say hypothetically, the buyer ultimately didn't get financing approval, right? And so they send their loan denial letter to the seller, and the seller says, I don't think this guy really did anything, or I don't even think he really tried to get financing. Well, guess what? They or their attorney can go back to this section and say, okay, we want to know when you applied for the loan, and we want to know that you use good faith and diligent efforts to obtain that loan, right? And if they didn't, then they're in breach of contract and would entitle the seller to make a claim on their deposit, even though the buyer received that loan denial letter. Or sometimes you get a buyer that says, you know what, I've changed my mind. I'm just going to tell my lender to give me a loan denial letter. Well, or they say, you know what, I've changed the buyer. I've changed my mind. I don't really want to buy this home anymore, so I'm just going to delay and not give my lender the requested information so that I get a loan denial letter. Well, guess what? Under this provision, guys, they both have the obligation to make loan application and then follow it up with due diligence and good faith efforts to obtain loan approval within that period, right? And thereafter close. And then it goes down here, buyer's failure to use good faith and diligent effort during the process shall consider to be a default under the terms of this contract, right? So again, guys, if you have a buyer that's not following up with their lender or is getting cold feet or whatever, this is where the seller or their attorney is going to look to say, hey, were you really diligent in trying to obtain your loan? And for purposes of this provision, diligent effort includes but is not limited to timely furnishing of all documents and information required and paying for the appraisals and other fees, etc. So again, if your client's not doing that, that opens your client, the buyer, up to being in default of the contract. So just make sure that they're doing that. This also means because they have a good faith and diligent effort to obtain loan approval, guess what? That also means that if they get a loan denial letter from one lender, yes, they should send that certainly to the seller and use that as a basis to get out. Now, I have seen sometimes where the seller comes back and says, okay, well, you didn't get it from that lender, that's fine, but have you tried anyone else? Because you have an requirement to use good faith and diligent effort to obtain loan approval, period. Doesn't say from RBC Bank, doesn't say from Synovus Bank, doesn't say from whoever. It says that you're diligently trying to obtain loan approval under those terms that we just outlined, which is, based on their credit worthiness, whatever. So, I have seen that too. So if it's a lender related issue, but not necessarily, due to their credit worthiness or whatever, that can be an issue kind of to keep in mind too. All right. Okay, going down here, buyer shall, upon written request, keep the seller and broker fully informed about the status of the loan application, including property-related conditions. Buyer authorizes the broker and the lender basically to provide them with information, that sort of thing. So again, guys, this is where the seller goes back directly to the lender and says, hey, were they providing you with the information? When did they make application? All that sort of stuff. So the seller does have the right to get that information directly from the lender. So again, due to the fact that I've been doing this for so long, this is, I see this over and over again where these are sort of the pitfalls. Okay, so if within the loan approval period buyer obtains loan approval, buyer shall notify the seller of same in writing prior to the expiration of the loan approval period. Or if buyer is unable within the loan approval period, but buyer is satisfied, then buyer can still proceed. Either way, you got to give notice to the seller within the loan approval period. Hey, I got financing, or no, I didn't, but I still want to go forward. Okay. If the buyer is unable to obtain loan approval within the loan approval period, after the exercise of all good faith and diligent effort, buyer may terminate by delivering a written notice of termination prior to the expiration of the loan approval period, whereupon the deposit will be returned. So again, guys, you got to give notice to the seller either way of the loan approval or loan denial, right? If the buyer fails to deliver any written notice to seller prior to the expiration, then buyer shall proceed forward with his contract as though there was no financing contingency, right? And then the last part, sub Romanet numeral 6. If buyer has timely provided for notice and thereafter fails to close, then deposit shall be paid to seller unless it's other contingencies or property related conditions of the loan approval, specifically excluding the appraisal valuation. So again, for you older timers, the old contract used to say, hey, if you got loan approval but the appraisal didn't come in prior to closing, then they had the right to cancel the contract all the way up to closing. That is no longer the case under this version of the contract. The appraisal has to be done within the loan approval period. If they don't get it done, if they get a loan approval but didn't get the appraisal, and then the appraisal comes out low after the loan approval period, guess what? The buyer doesn't have the right to cancel the contract based on the late appraisal. Point being, make sure the appraisal gets done prior to the loan approval period. All right, guys, moving all right along. All right, closing costs to be paid for by seller. The default is documentary stamp taxes are to be paid. The two primary costs are going to be, the two most expensive are going to be doc stamps on the deed and title insurance, right? So doc stamps are by default paid by the seller. It is negotiable in Sarasota County. It is certainly more typical that the seller pays doc stamps and the buyer pays title insurance. In some other municipalities, or certainly other counties outside of Sarasota, sometimes it's flipped. The buyer pays doc stamps and the seller pays title insurance. But like I said, in Sarasota, doc stamps paid by the seller, title insurance paid by the buyer. Some people say, well, what is doc stamps? I don't even understand what it is. Doc stamps is a tax paid to the Florida Department of Revenue upon the sale of real estate. As all of you know, Florida does not have an income tax, right? So how do they make up revenue without having an income tax? We do that by having a documentary stamp tax. The documentary stamp tax, just for your education, is usually the top 1 to 2 revenue generator for the state of Florida. So it's a very important tax. That's how we raise revenue in lieu of an estate tax or federal or state income tax. And so it has to be paid. Again, it can be negotiable, but usually the seller pays it. The amount, if you just need to figure it out quickly, it's the purchase price times 0.007. I think that may have been on your realtor test, but so that is how you calculate it. We also have some cheat sheets how to calculate quickly doc stamps and title insurance. It's a handout that we give as a quick reference guide. Both doc stamps and title insurance are based on the purchase price. So it's sort of a diagram that shows the purchase price and then shows the doc stamps and the title insurance. So if you're interested in that, reach out to our office. We can get you one of those. So that's on doc stamps. And then municipal lien searches, FERPTA cost, usually that's for the seller as well, and these other things here. And then here's a little known sort of, it's kind of, some people think it's oddly placed here, but it's an important part of the contract, right? So if prior to closing, seller is unable to meet the as-is maintenance requirement, sum equal to 125% of the estimated cost to meet the requirement shall be escrowed at closing. If the actual costs exceed that amount, seller shall pay the actual costs, etc. So what does this mean and why is it in here? So what this is sort of saying, guys, is the seller has an obligation to maintain the property in the condition that was signed at the effective date in the same condition, right? So if a storm comes through and there is damage after contract, right? A storm comes through, damages the roof, it's now leaking. What happens? Well, the seller has an obligation to maintain the property in the same condition. So the seller under that scenario would be required to escrow up to 125% of the estimated cost to repair it. And then after closing, the repairs are made. If it's less than the amount escrowed, obviously the seller gets that back. If it's more than the amount escrowed, then the seller has to pay the difference. We certainly can prepare and do prepare the escrow agreements at closing, which has a little bit more specificity as to who's going to do the work, the quality of work, all that sort of stuff. We do those at no charge as well. But that is in there, and that can be anything. It could be the walkthrough. You go in, the property's a mess. Well, the contract also requires that it be, given in good condition at the time of closing. So this gives the buyer the right to require the seller to escrow certain amounts to cover these sort of things that may come up in a walkthrough or before closing or whatever. It's already in there. All right. Okay. Costs paid by buyer. Again, obviously there are lender costs, that sort of thing. Municipal lien search, that sort of thing. So pretty much straightforward there. All right, title insurance. At least, again, usually just leave this blank and put in 15 days. That's typical prior to closing. There's going to be a title commitment that gets issued, and then down here, who's going to pay for it? Like I said, usually in Sarasota County anyways, it's going to be the buyer shall designate the closing agent, pay for owner's title policy. So title insurance, let's just talk about it for a minute, right? So title insurance, first of all, if your client, the buyer, is going to be getting a loan, then the lender is going to require title insurance, full stop. So if the buyer's getting title insurance, if the buyer's getting a loan, title insurance is going to be required. The cost, because their lender is requiring it, the cost for their buyer's policy or owner's policy is, I think it's like $250, so certainly worthwhile to get. I get a question more often where the buyer is not obtaining a loan, and the question is, do they really need title insurance? I will say that yes, it is definitely a good thing to get. So what is title insurance? Title insurance is a title policy. So it's an insurance product, and it insures the buyer of their ownership of the property from the beginning of time up to the date of closing, right? So, however long that property, and not just the building on it, but the actual, ground underneath it has been in existence, right? All that time, it's going to ensure that there's no problems with it, right? So what could some of those problems be? Well, in 1920, maybe that's going back too far, in 1970, there was a mortgage that was on the property that was never released. So, without title insurance, that buyer buys the property, he's taking full risk of anything prior in time that may have happened to that property. Could be wild deeds, could be wrong people's signing deeds. Deeds, trust me, get messed up all the time. It could be an encroachment from a neighbor. It could be a property encroachment from them onto their neighbor's property. Could be, people have died in the past chain of title, and there wasn't proper probate or state, done to get the necessary people to sign off on those deeds, that sort of thing. There's all sorts of things that can happen when you're talking about that much time, right? So the insurance covers that buyer, so they know on the day that they close, they don't have to worry about anything in the back chain of title. They're insured for it. So if somebody comes forward and says, hey, you're encroaching on my property, move your building or move, your driveway or whatever, they're covered. If somebody comes back and says, hey, there was an unrecorded mortgage from years ago that never got released, you owe me $200,000 because we have a mortgage on this property that we just discovered, not their problem. All these things they're insured for. They call up their insurer, they say, I have a title claim. The insurance company takes it on and fights that lawsuit for them. And I will tell you that the title claims business on the claim side, so where people make actual title claims, is a multi-billion, maybe not billion, I can't say that, but I know it's a multi-billion-dollar issue for title companies where these claims pop up all the time and they have to defend these lawsuits on their own dime. So anyways, long way of saying, I certainly think it's worth the cost. I wouldn't personally buy property without title insurance. You just never know what's out there. All right. Okay, guys, I'm going to kind of speed through some of this because I don't want to keep you here all day. Our survey is important. Yes, I think certainly it's good to ask a seller if they have a survey, but if I'm buying a property and the survey, if it's a couple years old and it's signed, make sure that the copy that the seller is giving to you is signed and certified and good. That's fine. We can use that. But if the seller doesn't have a survey, always good to get an updated survey. Make sure that you're seeing on the property. And by the way, if you're getting title insurance, we either have to have the seller's old survey or a new survey just to see it. But again, if there's any errors on that survey or there's any problems, that's protected by title insurance. All right, special assessments, section F. I get questions sometimes, what this means. These are relating to public body assessments, right? So municipal public body does not include condominium or HOA assessments. Those are going to be dealt with separately in a separate addendum for the HOA or condo rider. That's where those assessments would be addressed. This is just relating to municipal assessments. So something thinking of, like on Longboat Key where there's a special assessment and that sort of thing. Most option and the default, if neither box is checked, then section A shall be deemed. This is the most the most often sort of fallback, which is the seller is going to pay installments due prior to closing and the buyer is going to pay installments due after closing, right? So that seems fair. Buyer takes it over. They're going to continue to make those assessments after closing. If section B is checked, seller shall pay in full prior to closing all assessments allowed that can be prepaid. For any assessments that can't be prepaid, then option A shall be deemed checked. Again, guys, you want to be, if you're receiving this contract and you're not preparing it, you want to take a look at this stuff, right? So let me give you an example. Let's just say hypothetically that the buyer's agent prepared this contract and they checked B and you didn't really pay that much attention to it. Everybody's anxious to get the contract signed. So the seller signs it and that sort of thing. And then you get to closing and the buyer says, oh, by the way, there is a public assessment on Longboat Key and it's $10,000 that's supposed to be paid in installments, right? But since you checked this, guess what? You've got to pay for all those installments at the time of closing, which is $10,000. So make sure to include that line item on the closing statement for a $10,000 assessment so that the buyer doesn't have to take that over after closing. I would imagine under that scenario, the seller might be kind of mad and maybe saying, hey, why the heck was this checked? And why didn't anyone tell me, that I agreed to pay for these, assessments that were supposed to be paid in installments? Why am I paying all up front? So again, these sort of things matter. You want to take a look. Again, I would always, encourage you guys to make sure section A is signed. I think it's most fair for everybody unless there's really a special circumstance that would permit section B to be checked there. Okay? All right. This is pretty self-explanatory. Permits disclosure. Seller does not know of any improvements which were not made without the required permits. Et cetera, et cetera. If seller identifies permits which have not been closed and which were not been permitted, then seller shall promptly deliver to buyer all plans, et cetera, and all that sort of stuff. So it doesn't really say that the seller, basically the seller has an obligation to disclose any work that was done without permits. This does come up from time to time. The seller made, they built out their sunroom or maybe their garage into a room and didn't get the required permits. Well, guess what? You have to disclose that, and then the buyer can then go through and get it inspected, and then there may be back permit fees and inspections and all sorts of stuff that needed to be done. So make sure you're talking, if you represent the seller, make sure you're talking about this up front. Hey, did you make any improvements to the property that may have not been permitted? Because you want to address that before you go to contract. If nothing else, you certainly do have an obligation to disclose it. All right, these are some other these other disclosures. I will say in this flood zone, the section D is kind of important too, right? So what this says, this is often left blank. And if it's left blank, guys, then it's 20 days. What does it say? So it says basically if the lowest flood floor elevation of the building, rating for purposes is below the minimum floor elevation, or is not eligible for flood insurance through the National Flood Insurance Program or private flood insurance program, buyer may terminate this contract by delivering written notice to seller within 20 days after the effective date, right? So this is 20 days that the buyer has the right to terminate this contract based on the inability or ineligibility of flood insurance, or if the lowest floor elevation is below the minimum flood elevation, that sort of a thing. The thing is that under this as-is contract, if you leave it blank, the buyer usually has 15 days within which to complete their inspections and cancel. So the seller believes after 15 days, guess what? The buyer doesn't have the right to terminate their contract. But if this part is left blank and this says 20 days, and the buyer is looking for a way out and says, oh, by the way, I know my 15-day inspection period has ended, but I was not able to get flood insurance. I have 20 days to terminate. They can use this provision to do that. I only say this because if you have a seller that says, I want a hard contract after 15 days so that I know, so that I can start preparing moving and that sort of thing, I'm okay giving them 15 days but not a day more, then you want to make sure that this says 15 days too, so that this period does not extend beyond the inspection period. Because I've seen that before where sellers think I have an absolutely hard contract after 15 days only to find out that the buyer is now using this on day 20 to cancel, which can lead to problems. All right, I'm not going to go through too much of this. This section, subpart I, talks about FERPTA. This is when you have a foreign seller. There is a FERPTA requirement that they have to basically file with the IRS their FERPTA tax returns, and then a certain amount, usually 15%, has to get sent to from the proceeds of the sale, has to get sent to the IRS to be held until their final tax return is done, that sort of thing. So that's an obligation of the seller to do it. However, under federal law, because the United States doesn't really have jurisdiction necessarily over foreign sellers, they put this requirement onto the buyer. They say, hey buyer, if you're dealing with a foreign person and that foreign person doesn't send the necessary funds to us, that 15% or their 8288 forms to us, that sort of thing, in advance of closing, and we don't get our taxes as a result, guess what, buyer? You're on the hook for it. Some people don't know that. The actual penalty falls on the buyer, not the seller. The seller has obligations, but if they fail to do it, then the penalty actually goes to the buyer. So the buyer really has the interest here in making sure that those necessary forms and the amounts are submitted to the IRS at closing to make sure that they don't have exposure for any amounts that aren't paid. So if you're dealing with a foreign person or your buyer is dealing with a foreign seller, you definitely want to make sure that this gets done right. Our office can certainly handle this. If it's more complicated, we do work with a great international tax team that can really do just about anything when it comes to FERPTA or foreign investment taxes of any complexity. If you have questions about that, let us know. The bottom line for your takeaway is, if it's a foreign seller, be on alert and make sure that everything's done. All right. This is that as-is maintenance requirement that we talked about before. So, except for ordinary wear and tear, seller shall maintain the property, including lawn, shrubbery, and pool in the condition that is existing as of the effective date, etc. So you do have that. Kind of an esoteric sort of thing, but I'll just mention it. I have had situations in the past where it's a condo sale and it's not happening for 4 months during the summertime, and the seller's not living there anymore. And guess what he does? He turns off the electricity. He says, well, no one's there. What do I need utilities for, right? So the unit is left there languishing in the summer heat for 4 months. And the buyer is obviously concerned about that. Do they have a requirement? There isn't actually any really good case law on this. By the way, I actually had this. There isn't any, there is this as-is maintenance requirement, but that's really to maintain the property, so that would be like, lawn, shrubbery, condition of the property. But as far as utilities and that sort of thing, it kind of falls, I think, within a gray area. Anyways, probably doesn't come up a whole lot, but if you're worried about those sort of things, make sure it's covered in an addendum so that it's clear. All right, Section 12, property maintenance, property inspection. Most of us, kind of know what this says, but we'll go through it briefly. So buyer shall have however many days. 15 days is typical. I've seen it go to 30 or even longer. Usually, if it's commercial, you probably don't want to use this contract, but certainly commercial can be longer due diligence period. But anywhere between 15 to 30 days is certainly appropriate or common. All right, so if buyer determined in buyer's sole discretion that the property is not acceptable, buyer may terminate this contract and get a return of their deposit. So again, it's not based on their inspection specifically. The older versions of the contract did tie it to their inspections, said if the results of their inspections had problems, then they could cancel. It no longer says that. It just says buyer can cancel for any reason. If they wake up in the morning, get cold feet, they can cancel it, no problem there. Okay? On the day prior to closing, obviously the parties have the right to do that inspection, so that sort of thing. Okay, if buyer's inspection, subpart C here, identifies any building permits, then seller shall promptly deliver to buyer all plans and written documents, etc., to facilitate, let's see here, and shall promptly cooperate in good faith with buyer's efforts to obtain estimates to repair, to make the repairs and other work necessary to resolve such permits, right? So they have to provide necessary authorizations, that sort of thing. But in fulfilling such obligations, seller shall not be required to expend or become obligated to expend any money. So this is a common misconception. If there's an open permit under this contract, the seller isn't obligated to expend any money to close out the open permit. I know it seems odd. Seems like the seller should, and we do have some things in the contract that I think we can object to sort of encourage the seller to close out open permits and do the necessary work. But this provision of the contract specifically says that they don't. So again, it's kind of up to the buyer's efforts to complete the necessary work to resolve such open permit issues. Okay, so it's really up to the buyer to do that. Okay. These are just kind of disclosures. I do want to point your attention to section 14, which is professional advice and broker liability. This does have some very strong and clear language that protects you and the broker from liability. Okay, so, unfortunately, if you've been doing this long enough, you've probably run into a situation where usually unfairly somebody's pointing the finger at you, saying you've done something wrong, they're going to sue you, etc., etc. I usually point those people in a very nice way to this section 14 of the contract, which does provide to you a lot of protections. The only real thing that you have to be worried about is negligence. And what is a real estate agent's negligence? It's something that the average realtor should either know or should have known that they were doing, that should have been done differently, right? So would a reasonable real estate agent in the same circumstance come to the same conclusion or do the same thing that you did? If the answer to that is yes, then you're not negligent. If the answer is yes, a reasonable agent doing their job would have done something differently, then you may be looking at some negligent issues. But anyways, again, this part of the contract is for your benefit. You want to be familiar with it. All right, section 15, default. I'm not going to spend, I'll take a moment to say, I'm not going to spend the same amount of time going through the rest of the contract as I did the first part. The second part, thankfully, is more boilerplate, so hang in with me. We're getting to the end. But anyways, buyer default. So if buyer fails any obligations under this contract, including payment of the deposits, like we said, within the time period specified, buyer may elect to sue and to retain the deposit as liquidated damages, or at seller's option, seller may proceed in equity to enforce seller's rights under this contract, right? So again, I think everybody thinks, oh, buyer defaulted, the seller gets their deposit. Well, not really. Under the contract, the seller has the option to either keep their deposit or enforce the seller's rights under this contract, right? Which can be, specific performance and that sort of thing. So, and I'm seeing that more and more where sellers go, I don't want your $5,000 deposit. I'm going to sue you for actually buying this property. And oftentimes what they're trying to do is not necessarily sue the buyer with the full intention of making them actually buy the property. What they're doing is trying to either scare them into or ensnarl them into a lawsuit to then have more leverage to get more money from the buyer in addition to their deposit, or make it difficult for them, or at least give them leverage to seek other something else from the buyer. So again, if the buyer has a $5,000 deposit and the buyer just says, sometimes this happens, hey, you know what, I'm just going to let this contract go. I don't care about my $5,000 deposit. I'm going to default. He can have my $5,000 deposit. Well, guess what? Let's wait a second, because the seller does have other rights. The seller can sue you for specific performance, right? And again, that they can very easily initiate a lawsuit. Now you're going through litigation for maybe a long period of time. And by the way, under this section 17, if they're successful, buyer has to pay for their attorney's fees, that sort of thing. So if a buyer just says, I'm defaulting, I know I'm defaulting, I don't care about my deposit. Well, wait a minute, because you may be on the hook for a lot more, including their attorney's fees, if you're just flat out, defaulting. And on the other side, that's something, if you're representing the seller, kind of keep in mind too, right? Hey, we have other rights here, and if the buyer is being unreasonable, let's consider at least going down that road to see maybe if we can, get more concessions. All right, seller default. If for any reason, seller defaults, right? Buyer may elect to get their deposit back without waiving any action for damages resulting from seller breach, and pursuant may also recover such damages and seek specific performance. So this gives the buyer a little bit more rights here, right? So damages, what are damages if the seller defaults? So we get to closing and the seller refuses to close or whatever. Well, guess what? Buyer can sue for lost profits. They can sue for consequential damages. They can sue, hey, you know what? I had to hire my mover and my mover's in all sorts of things. They can sue for, including specific performance. So again, these are pretty heavy, could be heavy remedies in the event of either party's default. Dispute resolution. Basically, this says that buyer and seller will have, after the 10 days of conflicting demands, to resolve such dispute, failing which buyer and seller shall submit to mediation under paragraph 16b, right? So this basically says that before anything is done, if there's a dispute, the parties have to go to mediation after 10 days. So after 10 days, 10 days, you guys try to work it out. So again, buyer defaults, says have my deposit. Seller says, no, I'm not taking your deposit. They have 10 days to try to figure it out. After 10 days, they have to go to mediation, right? What is mediation? Mediation is basically a process where it's a quasi-judicial process, which means it's not really in front of a judge. It's usually in front of a court-appointed mediator. Each party can either get an attorney to represent them at mediation or not. They can represent themselves. And you go in, and the mediator is trained in trying to work out differences between the parties. You see if you can kind of come to an agreement. If so, you sign a final settlement agreement that says this is what we've agreed to, and that's that. Or if you don't, you come out of mediation, you say we can't come to an agreement. After mediation, then either party can sue each other and have their attorney's fees paid under an actual lawsuit. So dispute, mediation first, then lawsuit, and if lawsuit, then attorney's fees are paid to the prevailing party. So mediation is not binding, but you at least have to go through the process. Some people try to sue right off the bat. They say, you're in breach, I'm going to sue you. The first thing that the other attorney is going to say is, you didn't comply with this provision of the contract. We have to first go to mediation first. And by the way, each party has to pay their mediation costs separately. There's no attorney's fees provision for that. So each party has to pay that separately. All right, on to more stuff. In the interest of time, these are just kind of more standards. I'm not going to spend too much time here. This just talks about title, what is the seller's obligation is to convey insurable and marketable title at the time of closing. If you have questions about that, certainly reach out to me. I can talk all day about what that is. All right, survey. There's seller represents. There's ingress and egress, means they can get to and from the property. The lease information, we talked about that. And then again, time is of the essence. Calendar days are based on the property where the property is located. And then, let's see here. Okay, any date that we talked about this before, shall end on Saturday, Sunday, or national legal public holiday, as defined in section of United States Code 6103, shall extend until the next business day. Okay, the reason why I've highlighted this, right? So it's Saturday, Sunday, or national public holiday, but then it goes on as defined in this section. Well, that section specifies what national legal holidays are, and you'd be surprised. Some holidays or bank holidays are not actual national holidays, right? So you may come down to a date that is supposed to end on Monday, but it's bank holiday. Let's say a deposit is due on Monday, but local banks are closed, and you think it's a national holiday, so you don't make the deposit. But in fact, it was not a national holiday. It was a local bank holiday where the local banks were closed. Is the buyer still required to make his deposit on Monday? The answer is yes, because this section only accepts out national holidays, not local banking holidays. And they are sometimes different. So again, I don't want to scare you, but it's worth taking a look at this section. We're going to make sure that you know what the national banking holidays are so that you're not falling on a critical date and missing it. Good news is, on our website, preferredsettlement.com, we do have a critical dates calculator that does automatically calculate the dates for weekends, holiday, and national holidays, so that if you put in a date and put the effective date is X date, and I need 20 days from the effective date, if that 20th day falls on a national banking holiday, it will automatically populate it to the following day. So you can check that out on our website, another tool and resource for you. All right, I'm just going to spend just a moment here on force majeure, right? All right, so force majeure, act of God. Buyer or seller should not be required any obligation under this contract so long as the performance or unavailability of services, insurance, or required approval is disrupted or delayed by a force majeure event. Force majeure, of course, means hurricanes, floods, that sort of thing. And then the force majeure event will be deemed to have begun on the first day of the force majeure event prevents performance or non-performance essential to closing, okay? And then it says here, all time periods will be extended for a reasonable period of time, up to 7 days. However, if such event continues more than 30 days, then either party can terminate this contract, right? Why am I highlighting this, and why is this kind of important? Hurricanes. So, we had some issues where, it's one thing if a hurricane comes by us and they can't get insurance for 3 days. That's easy. It's extended. The closing is extended for those 3 days to get insurance. No big deal. But what happens if we have another big hurricane that comes through and actually hits Sarasota, and guess what? Utilities are knocked out, or you can't get parties to come in to make repairs to the property for a certain period of time, because everything's affected by the hurricane. What does this say? This says that it'll be extended for up to 7 days, but if it goes beyond 30 days after the closing date, then either party can elect to cancel the contract, right? So if you're closing on October the 1st and a storm comes through and you can't get services to the property or that sort of thing for a month after October 1st, so say November 1st, right? Then either party can cancel. Does this come up? Yes, it does. Have we been affected by hurricanes that affect these sort of things for long periods of time? Yes. So just something to look at, or at least keep in mind in the event that there's a hurricane. Take a look at this provision. Okay. All right. Let's see here. Anything here? I'll spend just a second talking about proration of real estate taxes. This kind of gets people confused sometimes, so I'm just going to mention it. In Sarasota County, taxes are paid in arrears. What does that mean? That means that the homeowner, when they pay their taxes in November, right? So November, that is for the taxes for that tax year. So if they're paying it in November 2025, that's for their taxes for the year 2025, right? So when they go sell a property, let's say in April, those taxes aren't due yet because they're not due until the tax bill doesn't really come out till November, right? So we estimate those based on last year's taxes, right? Because this year's taxes aren't due. We estimate them on last year's taxes, and that's how we prorate the real estate taxes. And then if the taxes come due, let's say they close in April, the new buyers move in, the new buyers get the tax bill in November, right? And then they go, well, this is different than what they estimated because they used last year's taxes. Under this contract, the buyer has the right to go back to the seller to ask for a reproration based on this year's actual tax bill, even though it was done after closing. It can be kind of tricky to understand that, but we certainly can help your buyers or sellers if they have questions about the reproration of taxes afterwards. We try to explain it at closing as well. But if, most people don't worry about it because it's not that much. Usually it's a couple $100 difference either way, but sometimes you do get that. Or sometimes it can be a dramatic jump and people do want to prorate. And again, we can walk them through that. Okay. I guess this is another one. Let's just talk about risk of loss. All right, this is a fun one. If after the effective date, but before closing, property is damaged by a casualty, hurricane, and the cost exceeds 1.5% of the purchase price, cost of restoration shall be an obligation of the seller, and closing shall proceed pursuant to the terms, right? Remember the escrow. of that 125%, right? Okay. If restoration is not completed as of closing, again, the sum equal to 125% of the cost shall be escrowed. If the actual cost of restoration exceeds the escrow amount, this is the provision that I was looking at. If cost of restoration exceeds 1.5% of the purchase price, buyer shall either elect to take the property together with the 1.5% or receive a refund of the deposit, thereby releasing seller and buyer, etc. Right? So what does this section mean, guys? Again, I hate to keep going back to the hurricanes, but it's important because if a hurricane comes, everybody has tons of questions. Thankfully, just know that really everything is kind of covered by the contract. If a hurricane comes through and the damage is more than 1.5% of the purchase price, okay, the buyer can either say, I'm going to take the property as is together with 1.5% of the purchase price as a credit. So they can say, yeah, that's fine. I know it's more than 1.5%, but I'm okay with it. I'll take the 1.5% credit and I'll buy the property anyways. Or they can terminate the contract and be released of the contract. So again, big hurricane comes through. There's a lot of damage to the property. It exceeds 1.5%. The buyer can say, forget it. I don't want to have to take that over. I'm going to cancel, get their deposit back. Okay? And then also, seller's obligation with respect to damage. Sole obligation with respect to tree damage shall be the cost of pruning or removal. So again, after a hurricane, property has big, beautiful palm trees, big, beautiful oak trees, whatever. Does the seller have an obligation to go back and actually replant those trees? No, they don't. They just have a cost of removal. But that cost of removal can be significant. And again, the buyer's going to say, oh my gosh, there's all these trees down to the property. Do I have to go out and remove this? What do we do? It's in the contract, guys. Okay. So this here, notice given by a party, by the attorney or the broker or real estate licensees representing a party shall be given as if effective by the other party, right? So this does give you guys authority to give notice on behalf of your parties, that sort of thing. It also says that all notices must be in writing and may only be made by mail, facsimile, personal delivery, or email. What did it leave out, guys? Text messaging, right? Does notice by text messaging is not technically sufficient under the terms of this contract. So it's an as-is contract. The inspection period ends at 5 o'clock on Monday. You're representing the buyer. You send the seller's agent notice, hey, my client is electing to terminate, but you send it via text. Guess what? That's not effective notice. Your buyer thereby waived their right to terminate. The seller then on Tuesday says, nope, we didn't get effective notice. You're required to proceed. Under that scenario, the buyer is going to be very mad at you, and under that, you would likely have been negligent because you should have known that text messaging is not sufficient. Also, any communications regarding any other deal points or that sort of thing, I know a lot of people use text messaging for communication, which is fine, but if you're talking about any things that are important or that are going to affect the contract, I would certainly suggest to you that you follow up in an email and say, per our earlier text message or per our earlier conversation, I'm hereby confirming X, Y, and Z. Please respond or please confirm by responding to my email, whatever. That is a best way to do that. Okay. The rest of this stuff is pretty standard. This here gets some people confused sometimes. Buyer waiver claims. To the extent permitted by law, the buyer waives any claims against the seller for any any damages or defects pertaining to the physical condition of the property that may exist at closing and be subsequently delivered by the buyer. Okay, so sometimes when you're representing a buyer, he sees this and goes, see, I told you it's as is, I'm accepting all the liability. Not really. Again, going back to what I said at the beginning, the seller still has an obligation to disclose anything that may have a material effect on the value of the property. So that can be anything, including if I'll digress, if there was a former suicide or some communities think that certain houses are haunted. If that is out there in the public knowledge, and that can be a reasonable basis for somebody to believe that that has a material effect on the value of the property, do they have to disclose it? Yes, just a fun fact. But anyways, my point going back is they are just taking the property in its as-is condition. So again, the seller doesn't have any obligation to make repairs to the property, but certainly has an obligation to disclose anything that they know is wrong with it. All right, the rest of these are just addendums, pretty self-explanatory. Some of these addendums are great. Some of them are not so great. I'm always here and always available to either help you with these addendums or, I have a whole catalog of, personally curated addendums for different things. So if you ever have questions about addendums, please don't hesitate to let me know. And GG is probably one of the most important seller's agreement with respect to buyer broker's compensation. Obviously, make sure you're getting that. If you're unfamiliar, I can't imagine that you probably are, but if you're unfamiliar with that rider, ask somebody, because you want to make sure that you get that, but I assume most of you guys already know. Additional terms, guys, I promise, I'm getting to the end. I'll just say that the additional terms, be careful. Listen to the little guy inside of you. If your clients are asking you to prepare additional terms that you don't feel comfortable preparing, don't try to wing it. That's where I see people get into problems. Something that seems very clear to you and to everybody when they're signing it. If you get down the road and there's problems, and let's say the seller gets an attorney and they look at these additional terms that you prepared and say, their job is to poke holes in it, right? Hey, it doesn't say this, doesn't say that, doesn't blah, blah, blah. You're going to be on the hook because you created these additional terms. Now, additional terms sometimes are easy, right? Buyer shall pay this cost, or a closing date is going to be changed to what, if it's simple stuff, don't worry about it. But if it's complicated, and again, inside you have certain, reservations about it, don't wing it, because that's where I see the majority of realtors get into issues where they're just doing things that they probably wouldn't have felt comfortable with doing in the first place. That's when you need to reach out to me or somebody else that you're comfortable with to help you walk through those. I do this. This is part of my job all day long, answering text messages from our clients saying, hey, can you send me an additional term for this or for that? That's what we do here. I can text it to you. I can prepare it for you. We do all of that. And again, we generally don't charge for any of that sort of stuff. We just want to be here as a resource for you. All right, the rest of this is pretty boilerplate, so I think we'll kind of wrap it up there. Just kind of parting thoughts. Again, a lot of these, even in more granularity, can be found in our agent commentary line summary. So check that out. Again, it's going to look something like this. Talks about the lines 6 through 24. What does it mean? Why does it matter? Agent tips, that sort of thing. So definitely check out that resource if you haven't. And then just, again, final thoughts is we've been doing this a long time, guys. We really do care about the people that we work with, whether you've been doing this for a year or whether you've been doing this for 15 years. Makes no matter to us. Each of you are important. We want to be part of your team. That's why we're doing these sort of seminars. I hope that you find it helpful. And again, if you need anything else ever, please don't hesitate to reach out to Preferred Settlement. Check out our website, preferredsettlement.com, or email us at info@preferredsettlement.com. I wish you a great day. Take care.